following are the number 5 to 10 prohibitions regarding wages under the Labor Code. Number 5. No employer shall make any deduction from the employee's deposit for the actual amount of the loss or damage unless the employee has been heard thereon and his responsibility has been clearly shown. Under the Labor Code, Article 115 on limitations. It means employers can take money from an employee's salary or benefits without telling them first. The employer must notify the employee if they think the employee caused a loss or damage. And employee have the right to explain on their side before the employer make any deduction from the salary. Like for instance, the employee broke the company's laptop, and before the employer make any deduction of what have been lost or damage, the employer must give a chance to explain their side on why the computer is broke, and the employer must prove first that the cause of the loss or damage is due to the negligence of the employee. 6. No employer shall withhold any amount from the wages unless authorized to do so. Labor Code Article 116, withholding of wages and kickbacks prohibited. This statement means wage or salary deduction is only applicable if it is authorized by the government. Your employer can't take money from your salary without a valid reason. I think the only valid reason to deduct a salary or wage of the employee is when it is authorized by the government, like for example is the taxes, social security system, PhilHealth, and other contributions that is authorized by the government. The importance of this rule is to protect the employees from unfair wage deductions. When number 7 says, no employer shall induce. When we say induce is to convince the employee to give up any part of his wages by force, is stealth. When we say stealth, it means doing something that is owned by other person without asking up permission of it. And intimidation, threat, or dismissal, or by any other means without the worker consent. Under the Labor Code, Article 116, withholding of wages and kickbacks prohibited. This means the employee must voluntarily agree to any deduction from their wages. The employer cannot take money from the employee's pay without their clear or consent. Number 8. No employer shall make reduction as consideration of a promise of employment or retention of employment. Labor Code Article 117, deduction to ensure employment. This statement means that an employer cannot reduce an employee's wages or pay as a condition for offering a job or keeping the employee on the job. In other words, it is illegal for an employer to use pay reduction as a way to get someone to accept or stay in a job. 9. No employer shall refuse to pay or reduce the wages and benefits or otherwise discharge the employee who has filed any complaint under this title or has testified or is about to testify in such proceedings. Labor Code Article 118, retaliatory measures. This law says that an employer cannot punish an employee for speaking up about unfair treatment at work. Specifically, if an employee files a complaint about their rights being violated, or if they have testified or about to testify in a legal case related to work issues, the employer is not allowed to stop paying the employee, cut their pay or benefits, or fire or punish the employee in any way. The number 10 says, no employer shall make any statement, report, or record knowing such statement, record, or to be false in any material. Labor Code Article 119, false reporting. It means that an employer intentionally lies or provides false details in any document or communication because it is against the law. The idea is that the employer must be truthful and honest in all records and reports and cannot knowingly provide false or misleading information. What are the allowable wage deductions? Deductions from the wages of the employees may be made by the employer in any of the following cases. Number 1. When the deductions are authorized by law, including deduction for the insurance premiums advanced by the employer in behalf of the employee, as well as union dues where the right to check off has been recognized by the employer or authorized in writing by the individual employee himself. Just like what I said a while ago, that an employee can only deduct an employee's salary or if it is authorized by the government or it is stated by the law. Like the insurance program that is operated by the government, such as SSS, Pag-ibig, and PhilHealth. And number 2, when the deductions are with the written authorization of the employees for payment of the employer agrees to do so, provided that the latter means the second one, does not receive any pecuniary benefit. Pecuniary benefit means a payment of money or any other object of value. It's either directly or indirectly from the transaction. This statement means that an employer can take money out of an employee's paycheck, but only if the employee agrees to it in writing. The employer can help make payments on behalf of the employee, like for benefits, savings, or loans. But the employer cannot make any money from doing so, either directly, like keeping part of the payment, or indirectly. The employer is just passing the money on as the employee has authorized. What are the requisites of deduction for loss and damages? Where the employer engaged in a trade, occupation, or business where the practice of making deductions or requiring deposit is recognized, the former may make wage deductions or require the employees to make deposits from which deductions shall be made, subject to the following conditions: that the employee concerned is clearly shown to be responsible for the loss or damage, and that the employee is given reasonable opportunity to show cause why deduction should not be made. And third, that the amount of such deduction is fair and reasonable and shall not exceed the actual loss or damage. And four, that the deduction from the wages of the employee does not exceed 20% of the employee's wages in a week. I think this part is the same on the number 5 of prohibitions regarding wages under the labor code. So I think I don't need to explain this part.
Before we proceed to wage order, let's talk about wage determination first. And wage determination refers to the process by which the appropriate levels of wages or salaries is established for workers. Usually, within a specific industry, occupation, or geographic region, this concept is particularly important in labor relations and employment, as it directly impacts workers' earnings and overall labor costs for employers. Here are some key aspects of wage determination. Number 1. Factors influencing wage determination, such as market conditions, cost of living, skill level and experience, collective bargaining agreements, and government regulations. Number 2. Wage determination processes. Number 1. Surveys and studies, legislative or regulatory action, negotiation. Number 3. Types of wage determination. Direct wage determination and indirect wage determination. Purpose of wage determination: to ensure fair compensation for labor provided by employees, to regulate wage levels, particularly in industries where exploitation may occur, to promote economic stability by helping workers earn wages that align with living costs and productivity. A wage order is a regulation or directive issued by a government body, particularly in the context of labor law, that outlines the minimum wage, overtime pay, and other wage-related standards for specific industries or occupations. So the question is, who issues a wage order? Well, a wage order is issued by the Regional Tripartite Wages and Productivity Board, or the RTWPB, whenever conditions in the region so warrant. After investigating and studying all pertinent facts and based on the standards and criteria prescribed by the Labor Code Article 123. Article 123 of the Philippine Labor Code pertains to the conduct of inspections and the powers of labor inspectors in the Philippines. Specifically, it outlines the authority and responsibilities of labor officials in conducting inspections in workplaces to ensure compliance with labor laws, particularly concerning wages, working conditions, and other related matters. Article 123 plays a crucial role in ensuring the enforcement of labor laws in the Philippines. It empowers labor inspectors to conduct necessary inspections and provide mechanisms for compliance and reporting of violations, ultimately aimed at protecting workers' rights and promoting fair labor practices. Question: when does a wage order take effect? Any wage order issued by the board shall take effect 15 days after its complete publication in at least one newspaper of general circulation in the region. IRR of the Labor Code, Book 3, Rule 7, Chapter 3, Section 4. Here are the common provisions regarding when a wage order takes effect. Number 1. Immediate effectivity. Some wage orders may take effect immediately upon publication in a newspaper of general circulations. Number 2. Grace period. This period typically lasts for a specific number of days to allow employers adequate time to adjust their payroll systems, manage budgets, and inform their employees about the changes. Number 3. Specific date. In a certain case, a wage order may specify a particular date when the new wage rates will become effective. Number 4. Coverage. The wage order will also detail which sectors and types of establishments are covered under the new wage rates, including any exemptions for small businesses or specific industries. For instance, if a wage order states, the wage order takes effect 15 days after its publication, employers must then comply with the new wage rates after that period, giving them time to adapt. Question: what is the remedy of a party aggrieved by the wage order issued by RTWPB? Any party aggrieved by the wage order issued by the regional board may appeal such order to the commission within 10 calendar days from publication of such order. It shall be mandatory for the commission to decide such appeal within 60 calendar days from the filing thereof. Labor Code Article 123, amended by RA number 6727. For appeal on wage orders are non-conformity with prescribed guidelines and questions of law, and grave abuse of discretion, NWPC Guidelines number 01 to 07, Rule 5, Section 2. Take note that the filing of the appeal does not stay the order unless the person appealing such order shall file with the Commission an undertaking with a surety or sureties satisfactory to the Commission for the payment to employees affected by the order of the corresponding increase. In the event such order is affirmed, Labor Code Article 123 as amended by RA number 6727.
Wage distortion. Wage distortion shall mean a situation where an increase in prescribed wage rate results in the elimination or severe contraction of intentional quantitative differences in wage or salary rates between and among employee group in an establishment as to effectively obliterate the distinction embodied in such wage structure based on skills, length of service, or other logical basis of differentiation. Labor Code Article 124 Par 7. Example of wage distortion. Senior employee A earns 600 pesos daily and junior employee B earns 500 pesos daily. A 50 pesos minimum wage increase benefits for employee B significantly, bringing their salary to 550 pesos. However, if employee A's salary remains unchanged, the pay gap shrinks drastically. This creates a sense of inequity for employee A, potentially impacting morale and productivity. The intended benefits of minimum wage increase is those partially offset by the unintended consequence of wage distortion. Resolving this requires careful consideration of adjustment to higher pay grades to maintain a fair and motivating compensation system. Ignoring wage distortion can lead to decreased employee satisfaction, higher turnover, and potential labor disputes. The element of wage distortion. Number 1. An existing hierarchy of position with corresponding salary rates. This implies that the company has a structured system where different job roles are categorized based on their responsibilities, skills, and experience, with each other having a designated salary range. Number 2. A significant change in the salary rate of a lower pay class without a concomitant increase in the salary rate of a higher one. This refers to the mandated wage increase, usually through a wage order that affects the minimum wage earners but doesn't apply to higher paid employee. 3. The elimination of this distinction between two levels. This means that the pay gap between the lower and higher pay classes has been significantly reduced or eliminated, effectively blurring the distinction between the two levels. And last, the existence of the distortion in the same region of the country. These elements ensure that the wage distortion applies to employees within the same geographical area where the wage order is effective. The role and correction of wage distortion. Number 1. In an organized establishment with sole and exclusive bargaining agent, the employer and the union shall negotiate to correct the distortion using the grievance procedure under their CBA. If it remains unresolved, it shall be decided through voluntary arbitration 10 calendar days from the time the dispute was referred voluntary arbitration, unless otherwise agreed by the parties in writing. IRR of the Labor Code, Book 3, Rule 7, Chapter 3, Section 7, Par 1. And number 2, in an organized establishment without sole and exclusive bargaining agent, the employer and the worker shall endeavor to correct the wage distortion. Any dispute arising therefrom shall be settled through a national conciliation and mediation board (NCMB), and if it remains unresolved after 10 calendar days conciliation, it shall be referred to the appropriate branch of the NLRC IRRR of the Labor Code Book 3, Rule 7, Chapter 3, Section 7, Part 2. The formula for resolving wage distortion. Any formula may be agreed upon and used by the parties seeking to cure the wage distortion. The court, however, approved of the following formula as a good formula to be used in the case of Metropolitan Bank and Trust Company Employees Union, ALO, TUCP, B, NLRC, GR number 102636, September 10, 1993. The formula: existing minimum wage over actual salary times prescribed wage increase equals distortion adjustment. Example: let's say a company has two job levels. Level 1, Level A, rank and file workers with a salary of 10,000 pesos. Level B, supervisor with a salary of 15,000 pesos. A new wage order raises the minimum wage to 12,000 pesos. Possible solution: Level A, the salary will be adjusted to new minimum wage of 12,000 pesos. Level B, to address the distortion, a smaller increase of 1,000 pesos could be given to Level B, bringing their salary to 16,000 pesos. This maintains a reasonable gap between the two levels while considering the employer's financial capacity.
I am Queen Marie B. Bragado from BSBA-HRDM 3D, and now I will be discussing about leaves. In labor and employment, the term leave refers to the period of time where employees are permitted to be absent from work, either with or without pay. It is based on the employment contracts and in the labor laws. There are several types of leaves. This includes the vacation leaves, maternity leaves, paternity leaves, emergency leaves, and many more. Are you familiar with the Service Incentive Leave or the SIL? So, Service Incentive Leave or SIL is a statutory benefit provided under the Philippine Labor Code to ensure employees have access to paid leave. It allows qualified employees to take a 5-day leave with pay annually after completing at least 1 year of service with the same employer. Purpose of SIL, wherein it aims to allow employees to take time off for personal, health, or family matters without losing an income. This is very important because it recognizes every employee and it gives rewards for their loyalty and trustworthiness. The second one, wherein it provides basic leaves benefit to rank and file employees or employees in the lower rank, particularly those who may not have other forms of paid leave. SIL or the Service Incentive Leave is for every employees, but of course with exceptions. So, who is eligible for SIL? All rank and file employees or non-managerial employees who have completed at least 1 year of service with the same employer is wherein it is either continuously or with breaks. It provides that authorized absences, holidays, or rest days do not disrupt the service count. Employment term or contracts allow for this cumulative period. 1 year of service means working for at least 12 months in the company, whether it is continuously or with breaks, who are excluded from the service incentive leaves. First one is the government employees, whether employed in the national government or any of its political subdivisions, including the GOCCs or the government-owned and controlled corporations under special charter or created by law. Why? Because government employees, whether working under the national government, local government units, or government-owned and controlled corporations or GCCs, are not governed by the labor code. Instead, they are covered by the civil service rules, which typically provide superior leave benefits such as vacation and sick leave. Or in short, government employees are not covered by the labor code. Instead, they are covered and governed by the civil service laws. Second one is the persons in the personal service of another. These are the individuals such as the domestic helpers or household staff, which they are excluded because their working arrangements are typically more informal and governed by specific laws such as the Kasambahay law, which provides equivalent or alternative benefits tailored to their unique employment conditions. Or in short, this persons in the personal service of another is a way or more informal entities governed by more specific laws which as especially associated with them. The third one are the managerial employees. They are exempted because their roles often include decision-making authority, discretion, and higher salaries. They typically receive better benefits packages, including customized leave arrangement that surpass the provisions of SIL or the service incentive leaves. After that, people includes are the officers or members of a managerial staff. Managerial staff are the people who are in the rank and file employees. They are the one who's governed by the managerial employees. These are similar to them because they are members of the managerial staff, have a lot higher responsibilities, independence, and are compensated with benefits. Besides the government employees, the persons in the personal service of another, the managerial employees, and the managerial staff, this also involves the fifth one, who's the field personnel. Field personnel whose work is performed outside the company's premises and who are largely unsupervised, which in short, they do not follow standard working hours or conditions. They can work anytime which they prefer. Their flexible work arrangements make SIL less applicable to their situations. The sixth one is the employees enjoying other leave benefits such as vacation leave of 5 or more days. Why? Because employees with at least 5 days of vacation leave or other similar benefits are considered to already have leave entitlements equivalent to or exceeding SIL, providing SIL in addition would duplicate their benefits. The seventh one is those enjoying vacation leave with pay of at least 5 days. Similar to the point above, these employees already received leave benefits that meet or exceed the SIL requirement, which it is only intended for those without sufficient leave entitlements. And the last one are workers in establishments employing fewer than 10 employees. Why? Because in small businesses with fewer than 10 employees are often exempted from certain provisions of the labor code due to financial constraints. These exceptions help micro-enterprises manage their operational costs while ensuring their survival. This law excludes these groups from SIL to avoid duplication of benefits, address specific employment arrangements, or alleviate the burden on certain employers, ensuring the policy remains fair and sustainable for both employees and businesses. So, what do we mean by at least 1 year of service? When we say at least 1 year of service, this refers to a minimum of 12 months of continuous or broken service, including approved absences and holidays. If the contract specifies less than 12 months, the employee still qualifies after completing 1 year. At least 1 year involves a minimum of 12 months. So what will happen if SIL is not availed of? If unused, the service incentive leave is commutable to cash at the end of the year, so it would be fair to other employees who availed the SIL. Under the Kasambahay law, domestic workers are also entitled to an annual SIL of 5 days, which cannot be carried forward to succeeding years.
Special laws are unique laws applied to specific groups or places, often referred to as a local laws or special legislation. They can be arbitrary or unconstitutional if not justified. In the Philippines, life imprisonment is a common sentence for crimes under special penal laws, such as drug trafficking, money laundering, and firearm possession.
What is parental leave? Parental leave shall mean leave benefits granted to a solo parent to enable him or her to perform parental duties and responsibilities where physically presence is required. RA number 8972, otherwise known as Solo Parents Welfare Act of 2000. Example, attending school meetings. Child refers to a person living with and dependent to the solo parent of for support. He or she is unmarried, unemployed, and below 18 years of age, or even 18 years old and above, but it is incapable of self-support because he or she is mentally or physically challenged. In the event that the parental leave is not availed of, it shall not be convertible to cash and non-cumulative. So, if solo parent leave is unused, it will be forfeited. So it is recommended for solo parents out there to take advantage of this leave benefit. What is the period for parental leave? In addition to leave privileges under existing laws, parental leave of not more than 7 working days every year shall be granted to any solo parent employee who has rendered service for at least 1 year. What are the conditions for entitlement of parental leave? A solo parent shall be entitled to parental leave provided that he or she has rendered at least 1 year of the service, whether continuous or broken. At the time of the effectivity of the act, he or she has notified his or her employer of the availment thereof within a reasonable time period, and he or she has presented a solo parent identification card to his or her employer. So, solo parent leave is a mandatory. So if you are solo parent, you must take advantage of these benefits so you can coordinate with your HR for the process on how to avail this one, and also go to the nearest DSWD office for the solo parent identification card. What is the rule on the unavailed parental leave? In the event that the parental leave is not availed of, said leave shall not be convertible to cash unless specially agreed upon previously. However, if said leave were denied an employee as a result of non-compliance with the provision of these rules by an employer, The aforementioned leave may be used as a basis for the computation of the damages. What is the grant of expanded maternity leave benefits? All covered female workers in government and private sector, including those in the informal economy, regardless of civil status of the legitimacy of her child, shall be granted 105 days maternity leave with full pay and an option to extend for an additional 30 days without pay. Provided that in case the worker qualifies as a solo parent under RA number 8972 or the Solo Parent Welfare Act, the worker shall be granted an additional 15 days maternity leave with full pay. RA number 11210, otherwise known as 105-day expanded maternity leave law.
Expanded maternity leave. Expanded maternity leave law under Republic Act number 11210 is a law in the Philippines that grants working mothers an extended period of maternity leave, allowing them more time to recover after childbirth and care for their newborns. It was signed into law on March 11, 2019 and amends the previous maternity leave law, which only provided for 60 days of paid leave. Number 2. Leave with pay. The maternity leave is paid through the Social Security system based on the employee's average daily salary credit. Number 3. Optional additional leave. Mothers may option for an additional 30 days of maternity leave without pay, extending the total period of absence of work. Number 4. Job protection. The law ensures that female employees are protected from dismissal during their maternity leave period. Employees are prohibited from terminating an employee on the grounds of pregnancy or maternity leave. Number 5. Applicability. It applies to all female workers, whether they are employed in the public or private sector, as long as they meet the requirements for SSS coverage. This also includes women working in the informal sector who are members of SSS. The goal of the law is to provide better support to working mothers, improve maternal health, and promote gender equality in the workplace by offering adequate time for recovery, bonding with the child, and adjustment to motherhood. What is the grant of expanded maternity leave benefits? The answer to that is, all covered female workers in government and private sector, including those in the informal economy, regardless of civil status or the legitimacy of her child, shall be granted 105 days maternity leave with full pay and an option to extend for an additional 30 days without pay, provided that in case the worker qualifies as a solo parent under Republic Act number 8972 or the Solo Parents Welfare Act, the workers shall be granted an additional 15 days maternity leave with full pay under Republic Act number 11210, otherwise known as 105 days expanded maternity leave law. Take note, in cases of miscarriage or emergency termination of pregnancy, 60 days maternity leave with full pay shall be granted. Can a self-employed woman who suffered miscarriage claim maternity benefits under the Social Security Act of 1997? The answer to that is yes. Voluntary or self-employed members of the SSS are entitled to maternity leave benefits. The Social Security Act uses the words female member without making any distinction between employees and those self-employed. Take note, maternity benefits shall cover all married and unmarried women, including female workers in the informal economy. Is a pregnant woman allowed to claim maternity benefits and sickness benefits simultaneously? The answer to that is no. A pregnant woman in the Philippines cannot claim maternity benefits and sickness benefits at the same time. Receiving maternity benefits automatically disqualifies a woman from receiving sickness benefits for the same period. This is stated in the Expanded Maternity Leave Law under Republic Act 11210, Section 5. What is the frequency of grant of maternity leave under expanded maternity leave law? The answer to that is maternity leave shall be granted to the qualified female workers in every instance of pregnancy, miscarriage, or emergency termination of pregnancy, regardless of frequency. In cases of consecutive pregnancy and multiple childbirths resulting in the overlapping maternity benefit claims, the female workers shall be paid only one maternity benefits, regardless of the number of offspring per childbirth or delivery. What is the rule on the allocation of maternity leave credits? The answer to that is, in the case of live birth, a female worker may allocate or transfer up to 7 days of her paid maternity leave to the child's father. This option is not applicable in cases of miscarriage or emergency termination of pregnancy, including stillbirth. In the absence of the father, the female employee may still allocate said maternity leave to an alternate caregiver who is either relative within 4th degree of consanguinity or a current partner, regardless of sexual orientation or gender identity, who shares with her at the same household.
Paternity leave. Paternity leave in the Philippines is governed by Republic Act No. 8187, also known as the Paternity Leave Act of 1996. This law grants paternity leave to married male employees, allowing them to assist their wife during or after childbirth. Here's an overview. Eligibility of paternity leave. Number 1. Married male employees in both private and public sectors. Number 2. The employee must be living with his legitimate or common law wife at the time of childbirth or miscarriage. Number 3. Paternity leave is applicable for the first 4 deliveries or miscarriages of the spouse. Duration of paternity leave. The law provides 7 working days of paternity leave with full pay. This includes basic salary, allowances, and other monetary benefits. Purpose of paternity leave. It aims to allow the father to assist his wife during childbirth or recovery from miscarriage. Number 2. The leave must be taken within a reasonable period, often immediately after the delivery or miscarriage. Exclusions. Unmarried fathers or those not living with the mother of the child are not covered by the law. It does not apply beyond the first 4 childbirths or miscarriages. So, what are the procedures that must be followed to be entitled to the grant of paternity leave? The procedures that must be followed to be entitled to the grant of paternity leave are as follows. Notification. A married male employee shall be entitled to paternity leave by filing the requisite leave application form within a reasonable period prior to the expected delivery. Number 2. Availment. The paternity benefits may be enjoyed by the qualified male employee on the days immediately before, during and after childbirth or miscarriage of his legitimate spouse, but it shall not exceed 7 days for each delivery. And number 3, validation requirement. Any employee availing the paternity benefits may be required to furnish the necessary documents, marriage certificate, birth certificate of the newly born child, and medical certificate, etc.
Gynecological leave is also known as Magna Carta of Women's Special Leave. It's a benefit that allows female employees in the Philippines to take up to 2 months of paid leave after undergoing gynecological surgery. Gynecological disorder are health issues that may affect women's reproductive system, including uterus, ovaries, fallopian tubes, breast, and external genitalia. Some common symptoms of gynecological disorders include abnormal vaginal bleeding, heavy cramps between periods, and spotting after menopause. To be entitled to gynecological leave benefits, you must meet the following conditions. Number 1, be a female employee. Number 2, work continuously at least 6 months within previous 12 months. Number 3, undergo surgery of gynecological disorders. Number 4, file an application with your employer.
Battered women leave refers to paid leave of absence of up to 10 days given to female employees who are victims of violence under Republic Act number 9262 with the Anti-Violence Against Women and Their Children o mas kinikilalang VAUSI Act of 2004. VAUSI is defined as any act or series of acts committed against a woman or child by an intimate partner, such as a husband, ex-husband, live-in partner, boyfriend, girlfriend, or dating partner. It also includes acts committed against the woman's child, whether legitimate or illegitimate. What are the acts being punished by RA 9262? Physical violence, sexual violence, psychological violence, and economic abuse. So, apat na bagay ang pinaparusahan ng RA 9262. Ano naman ang economic abuse? The accused in economic abuse did something or intentionally failed to do something with the goal of making the woman financially dependent on him. For example, financial support. The accused intentionally withdrew financial support. If you will notice in Section 5 of RA 9262, the withdrawal of financial support could either result in psychological violence or economic abuse. Physical violence. First and foremost, you harm, you attempt to harm, or you threaten to harm, or you place her or her child in a situation where they can be harmed. If you harm either of them, that is domestic violence. You can now be charged for violating RA 9262. Ano naman ang mga katulad ng sexual violence? Rape, acts of lasciviousness, yung pangbabastos o panghihipo, those kinds of acts. Pag hindi niya ginusto yun or you force her into these acts, then that is sexual violence. It is also sexual violence if you force her to watch porn or anything indecent. It is also sexual violence if you force your wife and mistress or lover to live in the conjugal home or sleep together in the same room with the abuser. You could also be charged with sexual violence under RA 9262. Even if she agreed to have sex with you or she agreed to do anything sexual in nature with you, ano yun? Kung ginagawin mo siya, ang correct term na yun ay coerce, then that is sexual violence. Then we proceed to psychological violence. When you perform an act or intentionally did not perform an act that will cause or is likely to cause mental or emotional suffering to the woman or his child if she experienced or anything you cause her emotional or psychological suffering or pagdurusa, that can already be considered psychological violence. For example, you cheated on her just once. If that caused her emotional or mental suffering, that is psychological violence. Ano naman ang harassment? In Section 5H of RA 9262, yan yung mga examples ng harassment. Ano naman ang economic abuse? The accused in economic abuse did something or intentionally failed to do something with the goal of making the woman financially dependent on him. For example, financial support. The accused intentionally withdrew financial support. If you will notice in Section 5 of RA 9262, the withdrawal of financial support could either result in psychological violence or economic abuse. How is the paid VAUSI leave computed? The computation of the paid leave includes the employee's basic salary plus mandatory allowances. Though probationary employees or contract of service personnel have access to this leave? The answer is yes. The VAUSI leave may be availed regardless of the victim survivor's employment status. Do I need to submit anything to No. VAUSI leaves are non-cumulative and non-convertible to cash. Can I use this even if my child is a VAUSI victim and not me? Yes. A female employee whose child is a VAUSI victim survivor may also avail this leave to attend to the legal or medical concerns of her child.